of advocacy. Otherwise, whatever lectures we give from this podium, it is not going to suffice. You should undergo the grind. You should understand the forensic skills of a lawyer. It's not that easy. You just learn and experience. Somebody comes and gives a case, we go and argue. We do not know whether that is right or wrong. There's so much to learn. We learn by experience. But if you're ready there to argue a case when somebody gives you, that can be only by training. I'm sure that the Bar Council would take my advice and start this institution, for which I don't think there are any roadblocks also for that. That is one. And number two, in your bar associations, I'll tell you my experience. I don't know whether you've heard of one judge by name Justice Muralidhar. He was practicing in the Supreme Court, later went and became a judge of the Delhi High Court, became a Chief Justice of Chandigarh and Odisha. He is now practicing again, he's doing very well as a lawyer, lucky fellow. When I shifted to Delhi, on Fridays, normally Supreme Court work completes, and then by afternoon people would want to go home. The judges also are not there, they finish the work and go. Muralidhar was sitting with about 10 people. Two of them are Supreme Court judges now, Vishwanathan and Narasimha, and a few others. For 2 hours to 3 hours, they used to discuss about the cases that happened in the Supreme Court for the past 4.5 days. Each of them had to give an account of what they argued or what they heard in a court in an interesting subject. So this group discussion continued from then, and even now that is going on. And one Mr. Seshagarrao, who is a lawyer, he is a lawyer from the erstwhile Andhra Pradesh, now Telangana, practicing there. He is continuing the tradition. So I don't know whether that happens here, but I would advise that in each bar association, such of those lawyers who are interested in learning, if they form a small group by yourself, and at least once in a week, if you can spend those 2-3 hours discussing about the latest development in law, assuming I'm a criminal lawyer. There are so many things to discuss about. In 1 week, there are at least 20 judgments on bails in the Supreme Court. Apart from that, there are so many questions of law that are decided by the Supreme Court. Or if I'm a lawyer doing civil cases, every week you have so much done in the High Courts as well as the Supreme Court. You have access now. Earlier we never had access, only books had to be referred to. So I would recommend and encourage that small groups are formed, and then if you can keep discussing like this and knowing what is the latest development in law, that would be very helpful for you. The other thing that can be done by the bar associations is, you have senior counsel practicing in those bar associations who are doing well. Request them, at least once in a week or once in 2 weeks after the court hours, if they can speak to young lawyers, 30, 40 of them, 50 of them, have interaction with the lawyers about what their difficulties are, what is it that is lacking, and what is it that they can learn. This interaction would definitely be useful to the youngsters. These are some small steps which do not need much, but it just needs some initiative to be taken by people in the bar association and the bar councils. So this said, I think I've harassed you for about 1 hour 15 minutes. If anybody wants to ask me any questions for the next 10 minutes.
One question, sir.
Yeah, please. Can you give me mic? Do I have 10 minutes?
Sir, actually I came to this profession after serving 30 years in central government. Recently I have joined this profession. I found that there are two types of styles, affidavits. In one style of affidavit, everything it is written, including the citations, prayer and case laws, everything. Only the covering, just like a covering letter, the petition will be there. As mentioned in the affidavit, we need this prayer. Another style is, entire thing will be in the petition, and in the affidavit we will verify those paras I am verifying it. Actually, which is better, and why affidavit should contain all the citations? And does it need to contain a prayer, actually?
Not necessary. Precedents need not be mentioned, but style is the man. Everybody has his own style of writing, as long as it is within the prescribed norms. See, what you are filing in affidavits, when you're talking of affidavits, are you talking of writ petition affidavits?
Yes, sir. Yes, writ petitions.
Yeah, see, this also
In
varies
Supreme
from-
Court also we filed in the second style. The entire pleading will be there. Only affidavit we will verify so and so paras. Whereas in High Court we found that first style, entire thing will be in the affidavit and only forwarding letter like petition will be there.
The practice in High Courts also is different because the form of petitions filed under Article 226 differs from the rules that are framed by the High Courts. In the southern part of India, you file affidavits and then a petition along with that. And the relief is shown at the last paragraph of the affidavit as well as the petition. In the normal course in those affidavits which are filed, you need a chronological list of dates. You can put it in an order that will be better, and the grounds that are raised for the purpose of seeking relief. I think that makes it very clear. When you come to the Supreme Court, you file a special leave petition, you already have a judgment with you. You have a list of dates and then you have the grounds, that's all. And the affidavit is only for verification. You need not file an affidavit of the person except for verification. As I said, it all depends on the rules. The idea is to ensure that whatever you are saying is clear. Writing hundreds of pages is only going to confuse the judge, and nobody has the patience to read all this if you want the judge to read it.
Yes, there is.
Yes, yes.